ago, like when we were in 2 years ago when we were both in 27? Yeah. Okay, got it. Yep. So I know just enough criminal law to make me dangerous.
I will say, it's been a pleasure to watch BJ grow as an attorney from, like the guppy stage when you are a law clerk, just graduating from law school, to a young,
That's the young part.
well, you're still young. Young, feisty, creative, public defender, trying everything, whether it works or not, just trying. And just watching her grow and mature as an attorney in the office and being, well, I don't know if you felt this way, but a mentor and a colleague.
Yes.
And then she is really smart. She left and did something else. She got stuck there and has become a high-level family law practitioner. And anyway, it's just a real pleasure to be here with BJ, and there you go. Thank you. Okay, so now we've done our introductions. We're going to do a quick overview. I'm sorry, this is a bit, you guys, the family law practitioners know this, but the criminal law practitioners might not. So the procedure for requesting a domestic violence restraining order, it is an ex parte procedure. That means no notice is required. The requesting party, so it can be an attorney, but it can also be a self-represented party, makes an ex parte application to the court describing the reasons that the person wants protection and the types of orders that they're requesting. The judge, bench officer is required to rule on these things very expeditiously. It has to be granted or denied under the code that day or the next judicial day at the very latest. Whether or not there is a temporary order, the hearing on the order must be set within 25 days, so it needs to be set fairly quickly. And the reason for that, of course, is if there is a temporary order, for sure, or even if there isn't, but if there is one, then there's someone whose liberty is being restrained, and you need to get it into court to at least have some type of decision on it. So it's a pretty quick, expedited procedure. The request for the order, as well as the temporary order, has to be personally served on the other party. Of course, it can't be served by the protected party. It has to be by a person age 18 or older, other than you. That's what I always tell people. It has to be a person age 18 or older, other than you, other than yourself. The temporary restraining order, if it's granted, those orders are all effective immediately. The big ones, I mean, there are a lot, but one order that's effective immediately is firearm prohibition. So the restraining party may not possess or have any firearms, and those have to be turned in within 24 hours, and then within 48 hours a receipt has to be filed with the court. There is a fairly new exception for peace officers, but they have to make a certain showing that they need that firearm for their employment and that they couldn't be reassigned to another position. We're going to talk about this more later on, but there is the possibility that the restrained party, the respondent, can file a written response. We're going to talk a lot about whether that's a good idea or not. But it's not mandatory. If it is filed, it has to be served at least 2 days before. You know what? So my view is if there are questions, as long as, because we've got a lot of material to cover, so if there are some questions, we're happy to take them, but we might have to just keep moving forward at some point if there's too many questions. So feel free to jump in, and you can jump in too. Was there one?
I had one brief question. So oftentimes when I notify my clients that they have to turn in firearms, the firearms are lost. My understanding is that's a crime to have a lost firearm and not reported. Is that?
So actually, I don't know about that, but it does come up, and I have not thought about talking about this, but when the system is working properly, there is supposed to be a screening that's done on the proposed restraining party so that the judge making a decision will know, does that person have any other restraining orders against them? Do they have any firearms registered to them? Do they have any warrants for their arrest? Do they have certain convictions, principally, other convictions for domestic violence? But so that information is all supposed to be available to the judge in deciding the TRO. I will say it's not always available. I think in Martinez, it is available when we're looking at these enrichments. Sometimes they just don't get back to us. And that is not a reason for delaying a decision on the TRO. So I don't know the answer if it's a crime to not report a firearm that's lost. But if you don't know it's lost.
In practice, I know it has been.
It gets charged.
I had an individual years after the fact, after having reported it, they ran the dross again, found that he still had a firearm registered to him, but it had been stolen from him, and he had reported it as such, and he was still charged as having, with a probation violation of having a firearm. Years after it.
Was that sustained?
Well, I'm fighting it right now.
Oh, okay. It's a pending case. I can't talk about it. Sorry about that. Sorry about that.
Not in front of you, different county, but nevertheless.
All right. So now the responding party or the restrained party is entitled, as a matter of course, to a brief continuance in order to prepare. But if the person wants a continuance, they should ask for one. That often wouldn't happen, so we would just have the hearing. And then at the actual hearing, whenever it happens, the judge will determine whether the protected party has prevailed by demonstrating, by a preponderance of the evidence that abuse has occurred. The order can be for up to 5 years. Different judges have different practices. I don't know what it is now. I thought there was kind of a default of 3 years was a very typical time, depending on the situation. It can be for less. And usually if I was going to make it for less than 3 years, I would often consult with the protected party to see what would make them feel safe. Sometimes what made them feel safe was 5 years. Sometimes, especially when it's more of like a parent-child situation, and there's a possibility that maybe things are going to get better, sometimes they felt like a year or 18 months, 2 years would do it. All right.
I'm going to talk about different types of orders that are available under restraining order. I'm going to go quickly through this because majority of us are family law practitioners. So you've got the category of orders not to abuse, which include no HAM, which is an acronym for harass, attack, molest, and the prohibition is actually much longer: strike, threaten, follow, stalking, etc. You also cannot disturb the peace of the protected party, and that would also include coercive control. And the definition of coercive control is a pattern of behavior that in purpose or effect unreasonably interferes with a person's free will and personal liberty. Family Code section 6320C will give examples of the coercive control, and very handily, so does your TRO and your restraining order after hearing. There's also no contact order, with exceptions for communicating with a protected party, for exchange of children. There's also the stay away order, with exception for exchanges. There's also the move out order, which is a very powerful order. There's no locating the protected party or take any steps to locate the protected party. You are prohibited from doing that, as well as any other orders that you wish to request from the court that would help to keep the protected party safe. There's also a protective order for animals, for control of property. For example, you are given sole possession of the family home or the family car. There's obviously the no firearms or ammunition order. You can also ask for custody and visitation orders. So even if a child or children are protected parties, they may also still have visitation with the restrained party, with the exception that the CPO, Criminal Protective Order, unless the CPO does not allow that. There's also orders you can ask so that the restrained party doesn't drop the family from his or her health insurance or change the beneficiary on other insurances. The protected party can ask to record communications from the restrained party. Property restraints, so you can ask the court to prohibit the restrained party from transferring, selling, disposing of property, so that if you have $100K in the bank account that's in the name of the restrained party, he or she can't just take that and transfer it somewhere else or dispose of it in any other way. You can also ask for the restraining party to pay the bills, such as your mortgage, rent, car payment, etc. You can also ask the restraining party to transfer the child's cell phone number to the protected party if the restraining party is the account holder. This is not ordered in the TRO, and neither is the pay bill. So this is something that once you get to your initial hearing, you can request it, but in your immediately temporary restraining order, the court is not able to grant the pay bills or the child's cell phone numbers. And the next category are also orders that are not available in the temporary restraining order, but are available after the hearing, including the 52-week batterers intervention class. Also, you can ask that the restrained party pay for expenses caused by the abuse, medical bills, damaged property, etc. Child and spousal support, you may request that, again, not ordered in the TRO, but ordered after a hearing. Also, you can ask for the restrained party to contribute towards your attorney's fees.
Anything on those before we go on to the criminal primer? So the first thing I was going to talk about is what might happen at the scene. So there's some type of intimate partner domestic violence incident at the scene. It's reported, law enforcement responds. And one thing that can happen is that the officer can seek an emergency protection order. And that's accomplished by the officer telephoning a judge, speaking to a judge, and potentially getting an emergency protection order that is short term. It can last for 5 business days or 7 calendar days, whichever is shorter. But it is also a very powerful order, and it can provide for complete no contact and stay away. It can provide for a move out. It can provide for temporary care, custody, and control of minor children. And I believe actually that animals can be protected as well in the emergency protection order. The order is supposed to tell the protected party on its face where they can request a more permanent order. So the location of where they can go to ask for the orders we were just talking about, the temporary and perhaps permanent domestic violence restraining order. So it happens very quickly, and it can happen at there's always a judge available 24 hours a day, every day, to take these calls. And they do come in a lot at night and on weekends, especially around holidays. And the restrained party has to be served with that order. That can be a little bit difficult if the restrained party is no longer at the scene. And that happens sometimes. One party will remove themselves and they're not there when the officers show up. But there's some interesting language in the code because if the officer gives verbal notice to the restrained party of the existence of the order and of its terms, that is actually considered service. A lot of times, and I think this is in the code as well, they can request the restrained party, I don't know if they're under an obligation to it, but they can request that the restrained party basically report to the police station and come pick up a copy of the order. And I can think of reasons they might not want to, but they can. But as long as they're given verbal notice of the contents of the order, that constitutes service. So, all right. So then, let's say oh yes?
Do they have to be told of all the specific conditions or just that it exists?
So I don't remember exactly, but it would seem to me, that they have to be told of like, hey, you've got this emergency protective order, you cannot go back to the house, you cannot contact the other party, potentially, or the children. You can't visit with the children, and you can't have any firearms. You can't steal the family pet. And this is good for up to 7 days. And then there's usually a date, there has to be a date on the order. And you have to move out immediately. So it seems to me that just saying, hey, there's an EPO, you can come pick it up if you want. I'm not sure how helpful that would be, and how would they really have notice of the terms. So hopefully the officer would be a little more expansive, and let them know what was prohibited or permitted. Okay, so let's say that the person who is the restraint party in the EPO is present at the scene. What can happen? Well, that person could possibly be arrested. And there's a difference between being arrested and being charged with a crime. They could be arrested and then held for up to 72 hours, but you have to minus out weekends and holidays. So it could be longer than that. I would say many intimate partner violence or domestic violence cases are filed as misdemeanors. And in my experience, most misdemeanors are not filed within that 72-hour period. In fact, there are actually plenty of felony domestic violence charges that are not filed within that 72-hour period. They're filed later on. And there can be all kinds of reasons for that. One thing that often happens is that the responding officer, the patrol officer, is there, takes some initial reports, makes some statements, and then sometimes it's followed up sometime later by an investigator or detective who may go out and get additional information, or may respond and talk to the victim again and take some photographs a couple days later. So there can be reasons why the case just isn't quite ready to pull together and be filed within 72 hours. So most misdemeanors would not be filed within 72 hours, but they might be filed at a later time. And then, once it is filed, there are two options. One, the case can be presented to a judge for issuance of an arrest warrant, or the case can be presented to a judge for issuance of a notice to appear. And I would also say that just because an arrest warrant is requested doesn't necessarily mean an arrest warrant will issue. There are different considerations. Let's say that this is being presented in November and the alleged date of offense is March. Well, if it's a misdemeanor and I've looked at the police reports and it's not egregious or particularly frightening, I might think twice about issuing an arrest warrant in November for something that happened in March. But maybe not. I mean, if it's clear from the reports that there are priors, if it somehow becomes clear that the person is on probation, certainly for a crime of violence, then these are things that might make me say, okay, a warrant is appropriate in this case. So anyway, either notice to appear or warrant, and one of those two things is going to get the person into court. A notice to appear might arrive, and then the person may choose to appear on the date that's set, or if they're arrested on the warrant, then they have to be brought in front of a judge quickly to be arraigned. On domestic violence cases, the accused person is required to appear personally in court. Unlike many other misdemeanors, when an attorney can appear for her, like most DUIs, many times, certainly if it's privately retained counsel, there can be a what's called a 977 appearance. So Penal 977. It's a misdemeanor. The attorney can usually appear, enter a plea, and do a lot of the things without the client there, but not for a domestic violence misdemeanor. And the accused must be present for arraignment and at sentencing, and if there is a criminal protective order issued. So what happens at the formal arraignment? Well, that is a proceeding in which the accused person is informed of the charges. I will say almost every time there's an arraignment, the attorney will waive formal reading and advisement of the charges. But if they didn't, then the judge would be required to read or at least summarize, basically giving you notice this is what you're charged with, these 4 counts, and this is what they are. Also, the judge has to verify that the person who's before the court is actually the person who's charged. What if it's the other Maria shop? It's not you, it's the Maria shop, and it's like, I don't know, someone else.
Off the top.
Right, that's right. It's like, oh my goodness, and the date of birth is different? That's not you, So anyway, they're just trying to make sure it is the person, and that's required, that there be some type of verification that the person is charged by their true name and the date of birth, right? Yes?
Under Penal Code 989, technically you can proceed on the name laid out on your, in the charging document, even if not
That's true.
accurate.
That's true, but I think but then the accused is agreeing to be tried under that name. So if it turns out that that's not really you, you're agreeing that you're going to be tried under that name and that everything.
I think it's just an agreement to proceed under it versus saying that that's your name per se.
That's correct, and there may be reasons why you wouldn't want to say that that's your name. But if you want to proceed that way, then you're basically agreeing that you're going to go ahead and the whole thing can happen and that this is going to be you for purposes of this case. Yeah, that's true. Yes, sir.
Is there any such thing as a felony domestic violence?
Absolutely there is, and I would say that most in-custody filings, so within that first 72-hour period at the time of arrest, if there's a request for a warrant to be filed within those 72 hours, the case has been reviewed by the district attorney, they decided to bring charges. Most times, if it's happening in that quick time frame, it would be a felony.
Give an example.
That might be just based on the severity of the injuries, if there are injuries, or the severity of the conduct. It could be on the prior record of the accused person, or maybe that person's on a grant of parole or probation. So there might be a reason why, some of it's going to be how quickly the police agency brings it in. I mean, the district attorney isn't just like sitting around like saying, hey, bring us cases, bring us cases. They're there, and they can only act if something is brought to them. So if for some reason the police agency thinks, hey, this is like really scary, this is really, there's a big risk here for the alleged victim, then they might expedite it and get it into the DA in time. And a lot of times, that's what many judges are doing toward the end of the day. When you're still at the courthouse, people are coming in and the person is about to time out. That is, the 72 hours is about to expire, and they want, to get the case filed and a warrant issued because that will keep the person in custody. And then usually they're heard on the calendar the very next day. They have to be brought in front of the judge quickly. So really, the seriousness of the case and whether the investigation is complete. That's another thing. The police agency can bring it to the district attorney, and they can look at the case and say, well, I need you to go back and do this and this and this, and we need more information, and we got to get some pictures. So they may reject the case the first time if they think additional investigation is needed.
So I think family law practitioners, we rarely see the serious felony charges coming in through a DBRO request, because if it's a serious felony charge, one, they are probably not let out of custody, and two, they're going to remain in custody for a while, and then the CPO also will cover a lot of what you're asking for in the DBRO. So that's why family law practitioners, we only normally see the out of custody misdemeanor charges for DB.
Or maybe felony charges where the person is able to post bail.
Yes.
Can I interject here?
Of course.
Thought or question. Would you recommend getting a DBTRO pending the criminal proceedings on a misdemeanor if there is a CPO or an EPO in place?
Well, I'm not going to make any recommendations, but I'll give some thoughts.
What would BJ recommend?
Just to give you some thoughts. The EPO is only good for 5 business days or 7 calendar days, whichever is shorter. So, if that's enough protection for the protected party, well then, okay. We'll get to some sort of crossover issues in a bit, but did you want to?
Did you say EPO or CPO?
CPO or EPO.
CPO, okay. If, for example, the protected party wants some sort of visitation for the kids, that would be a good reason to file a DBRO.
Or if there's a request for any of those other orders that you can't get in a criminal protective order, like support or
Move out.
I've had a case where,
you can get
Oh, you can.
You can get a move out in a CPO.
we had a case where the CPO that was it was dismissed because the case was dismissed, and only because we had the DVRO in place was there any ongoing protection, because the case was unexpectedly dismissed and the CPO became invalid, so it was very helpful to have the DVRO in place.
Okay. What else happens at arraignment? I would say it's very unusual for a case to settle at arraignment. Very, very unusual, because people just don't have enough information, or the defense counsel may not even have the police reports. So, I probably, in terms of an intimate partner violence or domestic violence case, very unusual for it to settle at that first appearance. I would, like, the one exception that I can think of is that maybe there was a delay in the filing and usually, well, defense counsel and the district attorney have something all wired and ready to go. In my experience, that's very uncommon. So the judge is also going to decide on conditions of release. Let's say the person's in custody and her attorney is asking that she be released either on home recognizance or supervised release if it's a felony, or that some affordable amount of bail be set. And so the judge can order conditions of release, such as comply with a criminal protective order. There are judges who, even at that early arraignment stage, might order anger management as a condition of release. And as a condition of your release, you have to obey all laws and follow all orders of the court, and I'm ordering you to enroll into anger management immediately. I don't personally ever put an end date on that. I just say until further order of the court. And then also, usually at arraignment, the accused enters a plea, and then the issue of how quickly the case is going to proceed is addressed. That's what we call the time waiver status. If a person is not, it's a misdemeanor and the person does not want to waive time and they're out of custody, the trial needs to be set within 45 days. If they're in custody at the time of arraignment, even if they're released that day, but if they're in custody at the time of arraignment, the trial needs to be set within 30 days. That's for a misdemeanor. But I would say most cases, and certainly when the person is out of custody or is going to be released from custody, most cases would be set on a time-waived basis. So it's not going to happen that quickly. And so we're assuming right now that there's what's called a general time waiver, so there's no end date for the general time waiver. The case is just sort of going to be around until it's not. What would be the next step? So plead not guilty, general time waiver, and what do we want next? Maybe not a jury trial. In many jurisdictions, it's called a pretrial conference. In this county, that we've moved away from pretrial conferences on misdemeanors, just in part because of the volume and sort of experience that it wasn't really a productive proceeding. I know that in the Richmond courthouse, we set something called a change of plea date. So you're not setting a trial, you're not quite ready to set a trial, but maybe the parties are going to work on trying to resolve the case and they need to get discovery, police reports. You might set a change of plea date a few weeks out. Or you could set a jury trial date. So we talked about the time limitations and the criminal protective order. So the controlling law in the criminal protective order is Penal Code Section 136.2. And it essentially says that the judge can make pretty much any order that you can make in a DVRO, with the exception of the financial orders and things like that. But you can order all of the no, harass, attack, strike, threaten, molest, assault, sexually or otherwise, follow, stalk, molest. You can order all of those. You can order no contact. You can order stay away. You can order stay away from a particular location. You can order that the protected party has the right to record communications that are made. There are other, obviously there's a no firearm order and a requirement of turn-in or surrender of firearms.
On the screen, which is...
Oh, the bottom one. Oh, yeah, we're going to get to that. That's really important. So, if, this is really important for the criminal law practitioners. In a situation where there are children and the potential of visitation with children, you should alert the judge at arraignment that that is the situation, because the judge may not know. Lawyers think that the judges know everything, but we don't know everything, and we certainly don't know more about the case than the attorneys do. Yeah, I would say in general that's correct. So, and if you alert the judge that there's an issue of visitation, then the judge can, on the criminal protective order, and this is CR 160, the criminal protective order, the judge can check box 16, famous box 16. And I think that's a really, I know family law judges feel that box 16 is really important because if that box is checked, and then one of the two, A or B underneath, that gives the family law judge the authority to make some orders for visitation that can actually be implemented. Because if that box isn't checked and there's a no contact order, either just with the other parent or if the children are named as protected persons, which they can be, if that box isn't checked, then no matter what the family law judge orders, that order can't be given effect, right? Because there's a no contact stay away order in this criminal protective order. It takes precedence over every other order.
So Judge, what if you're in arraignment and things are happening really quickly and the defense attorney forgets to tell the judge that there are children? So box 16 is not checked. So now we go back to the family law attorney. The family law attorney is screaming to me down. We can't have visitation.
Then the criminal defense lawyer is probably going to see about adding the case back on calendar in the criminal court to modify the criminal protective order.
And how difficult is that? Is it set 3-4 months out?
No, I mean,
We're used to that with RFOs, right?
No, it's not that bad. I think you would, yeah.
Why would you, as a bench officer, not just check the box? Even if you didn't know, it just, you have kids, I'm guessing.
Well, now there are some bench officers, especially, people who are sitting in criminal but have actually done family law, who might think to ask proactively, does the defendant and the protected party, do they have children in common?
Right.
Is there a family? Now, here's a real big difference between, so there are judges who do. There are judges who proactively ask. And I would say the judges that who do that are judges who've been assigned to family law. And I'm not tooting my own horn. There are other judges that I know who take this seriously. There's a real difference between box A and B, because box A makes reference to an existing order. And so the criminal attorney needs all kinds of information to provide to the criminal court judge. You need a case number and you need the date of the order. Now I would say, if it's a pre-existing custody order that was in existence before the event that has led to this criminal case being filed, then maybe the best thing to do is check box 16B, which refers to sort of a prospective order, an order that's made after this date. Because wouldn't you want the family law judge to have all the information and to make orders that are based on contemporary facts and what's best for the children, what's safest for the children and the protected party, because the 16 also can allow brief or peaceful contact with the other parent for the exchange, only for the safe exchange of children and court-ordered visitation. See that? That's right at the end of 16, right? Yep.
I have another question. Where do part of clients get these if they lost theirs?
So the original copy of the
Well, people, it's so hard to
It's
check.
entirely true.
I believe that it is a document that's available in the public section of the criminal court file. I believe that it is.
Okay.
So they probably have an attorney in the criminal case, even if they don't have an attorney in the family law case. And that, I think that getting a copy of the criminal protective order shouldn't be a problem.
I think you can get it from the clerk for 50 cents a page.
Sorry?
Okay.
I think that you can get it from the criminal clerk.
Yeah. Okay.
There just might be a cost involved.
Oh, I was just going to explain, you may hear something referred to as a CLETS order. All the orders that we're talking about, domestic violence restraining orders, the emergency protection order, and the criminal protective order. These are all orders that are entered into CLETS, which is the California Law Enforcement Telecommunications System. And this is a system that allows law enforcement to be able to see, hey, there's an order in place. Is it a no contact order? Is it a good conduct order that allows contact? What's the expiration date? And has it been served? So if it hasn't been served, then they can at least give verbal notice. Oh, one other thing, and Ariel mentioned this, I don't know if there is a mandatory judicial counsel form for terminating a criminal protective order. And this is a form that, in my experience, is often forgotten. That is, the criminal case resolves or gets dismissed, the situation Ariel was talking about. But no one does anything about the criminal protective order that's issued, and if no end date is put in on the first appearance, it's valid for 3 years. So I can see problems where the case was dismissed, so really the criminal protective order should have been dismissed, but it's still sitting around there in CLEPS because no one filled out that form. I will say I do it, but I don't know how often it's done. So that's something for criminal law practitioners to remember, like, the case gets dismissed, don't leave the CPO hanging out there.
If you just ask the judge to also end the CPO, is like the minute order enough? Will that be put through?
There's a mandatory judicial counsel form, and I think it's like CR 165, don't quote me on that one, but it's just a couple after 160, and that's the one. It's very easy, it's not as, and by the way, this form, I happen to know because of my involvement on the Criminal Law Advisory Committee for the Judicial Council. They're about to revise CR 160 to include all of the language that's now present from the Family Code about coercive control, things like that. I do think what will happen is that the form will no longer fit on one page. They've done it. Yep, CR 165, woo! It is CR 165 to terminate the criminal protective order. Now,
And if I jump in, it specifically has a box that specifies it does not terminate any existing family, juvenile, or probate court orders.
right. So that's where you would have been good. But they probably didn't do this in a criminal case.
No, they didn't actually, which is interesting. But I have the detail.
So, I don't know, we're still kind of at arraignment, but I'm thinking forward about CPOs. After conviction, if there's a conviction, and then a new criminal protective order is issued as a term of probation or as part of a prison sentence, that order can be, the post-conviction, post-resolution order can be in effect for up to 10 years. So, okay. Now, this is something that we forget about sometimes, but it's in the Constitution. It's the right or the privilege against self-incrimination, the constitutional right not to testify. I always tell prospective jurors that this is something that is so important that the framers put it in the first amendments into the Bill of Rights. And essentially, I used to tell my clients is that this means that you have the right not to say anything out of your own mouth that might get you in trouble or might support a conviction. So in a criminal case, the accused, of course, has no burden of producing evidence. He or she can rely on the state of the evidence, whatever the prosecution's evidence is, and argue that, hey, prosecution didn't prove that I'm guilty of anything, and they certainly didn't prove it beyond a reasonable doubt. The jury, the trier of fact, or the jury, which includes a jury, is told that when a defendant exercises the constitutional right and does not testify, that fact cannot be used against her and cannot be considered for any purpose or even discussed during jury deliberations. That's pretty much exactly what the jury instruction says. So, we're at the hypothetical?
We are.
Great.
All right.
We're going to read to you, like you're a bunch of kindergartners.
All right. Harry and
Oh, wait, sorry, was there something else? No? I thought I heard something. Okay, sorry.
Harry and Wendy were married for 15 years and 3 months and separated in January of 2022 after a TV incident. They have a 13-year-old daughter named Dorothy. In 2015, Wendy was convicted of a misdemeanor for embezzling from her employer. In the last 5 years of the marriage, Harry was abusing Ritalin on and off. This negatively affected Harry's relationship with Wendy and Dorothy. Harry was frequently irritable, paranoid, or depressed.
Sounds like me.
When Harry was irritable or paranoid, he became verbally abusive to Wendy and Dorothy. As a result of Harry's abuse, Wendy and Dorothy are very bonded. In addition, Wendy has been the primary caretaker of Dorothy.
So welcome to the world of family law hypos, where everybody's Harry and Wendy. In October 2020, Harry successfully completed a private drug treatment program. Wendy noticed significant improvement in Harry's behavior in the ensuing year. Unfortunately, in August 2022, Wendy noticed Harry acting overly confident and often irritable again, symptoms that she noticed Harry experience when he was abusing Ritalin. On October 15, 2022, Wendy found, hidden in the garage, several empty bottles of Ritalin prescribed for different unknown people. Wendy brought Harry to the garage and confronted him with the empty bottles. Harry denied using again. He claimed the bottles were from his former addiction. Wendy did not believe him, and a heated argument ensued. Dorothy, the daughter, heard arguing and went out to the garage to look. Harry got angrier and more aggressive. At one point, Harry was yelling at Wendy and walking menacingly towards her with his fists balled up. Wendy grabbed a nearby hammer, raised it above her head, and said, "This ends tonight!" and took a step towards Harry with the hammer still raised. Dorothy screamed and ran back into the house. Harry ran after Dorothy, and Harry called 911.
Distraught over what occurred, Wendy immediately left the garage and ran to her best friend neighbor's house. Yes.
The hallway.
Okay, best friend neighbor's house. When the neighbor opened the door, Wendy was hysterical and sobbing. Wendy blurted out, "I thought Harry was going to hurt me. He was screaming at me, he was spitting, and he had his fists balled up. And then he came towards me. I grabbed a hammer and raised it above my head. And then Dorothy screamed, and they both left." Police arrived and interviewed the parties separately. Harry informed the police that the parties were arguing because Wendy accused him of abusing Ritalin again. They were both yelling. Suddenly, Wendy grabbed a nearby hammer, raised it, and said, "This ends tonight," and took a step towards him. Dorothy screamed and ran back into the house. Dorothy saw the whole incident. Harry fled. He followed Dorothy into the house and called 911. Police tried to talk to Wendy. Wendy, who was still crying and distraught, only said to police, "What have I done? I raised the hammer, but I don't know. I don't know if he meant to hurt me." Then Wendy stopped talking to the police and invoked her right to remain silent.
Way to go, girl.
A little late.
A little too late.
Wendy was arrested and taken to jail. At the scene, a police officer called the on-duty judge who issued an EPO protecting Harry and Dorothy and served Wendy.
Fast forward to October 18th, 2022. Harry has requested a DVRO in family court, alleging the parties were arguing, when Wendy raised a hammer over her head and took a step towards him, saying, "This ends tonight." Harry also alleged Wendy threatened him in Dorothy's presence. The court granted a temporary restraining order on October 19th with a no abuse order, a no contact order, and an order to stay at least 100 yards away from Harry, Dorothy, and the house, Harry's car, Harry's workplace, and Dorothy's school. Both Harry and Dorothy are protected parties. The court ordered no visits between Dorothy and Wendy pending the hearing on November 7th.
Police agency was on it, the DA's office was open, and on October 19th, Wendy was arraigned on misdemeanor charges of brandishing a weapon, Penal Code 417, sub A, sub 1, simple assault, Penal Code section 240, child endangerment, Penal Code section 273A, sub B, all misdemeanors. Wendy pled not guilty, waived time, and was released on bail. Judge issued a CPO. Further hearing is set on November 21st.
Okay, so we have some questions for you. Or you have some questions for us. So in the DVRO matter, should Wendy file a written response, which is on the form DB-120?
Yes,
Who said yes?
I did.
Okay.
Okay.
All right. Okay.
We'll go over some of the advantages and disadvantages. So, yes, it
Yes.
does present her defense to the judge. However, most written responses are due 2 court days before the hearing day. So there is a potential that it is very, very early in the case, and it locks Wendy to a set of facts and defense early in the case before she has conducted any discovery, potentially had an investigator talk to any witnesses, and she's committed everything on paper. Also, it may be used against her in her criminal case. So, in criminal defense cases, the defense counsel can certainly look in the family court file, which is a public file, and take a look at the family law filings, because once in a while you might just get a, you definitely get the alleged victim's statement in the domestic violence restraining order application, where they have to lay out the facts that justifies them getting the application. And again, oftentimes these DVRO requests are filed so quickly after the incident that you may just catch them changing some facts that's different than perhaps what they told the police officer, and certainly perhaps what they then told the DA investigator. So I think it's a good idea to go look in, for defense attorneys to go look in the family law file to see what type of declarations they filed. And Judge, should the DA look at the family law file?
So I would say, so just generally, my view is that family law, the ones that are available to the public, which is almost all of them, right, except heritage cases, those files are underutilized or underviewed by criminal law practitioners on either side. Honestly, I'm not even sure that they even know that they're there.
A lot of times, no.
Maybe it'll be different now that it's available online. Certainly you don't have to go somewhere and look at a file in a musty clerk's office, but so here are the competing considerations. Of course, if you're defense counsel, you're really going to want to know what the other side said under penalty of perjury in something that they filed with the court, because that could be golden at some point, maybe even during trial. And the great thing for a defense attorney is you do not have the obligation to turn that over. That is not discovery that you're required to turn over to the prosecution, because it's for impeachment. And it's not. Now you do have to turn over statements that you obtain from witnesses whom you intend to call at trial. That the defense does have to turn over. But you're trying to prepare your cross-examination of the complaining witness, and so you go and get what he wrote down in his DVRO request 8 months ago, and you don't have to turn that over until you begin to impeach him with it on the stand. And then you have to turn it over to the DA, because it's an inconsistent statement, and you've just asked him, isn't this thing true that you wrote down? And he says no. And then you just hand it over to the DA, and you keep on questioning. Well, judge will probably give the DA a few minutes to read it, but then you can just keep on questioning. Now, your question, should the DA look at it? This is really interesting, because I don't think they ever do.
No.
The district attorney, the prosecution, does not have an obligation to go out and gather information from sources that are not law enforcement. Of course, if law enforcement or anyone related to the prosecution team obtains information, writes a report, gathers evidence, that all has to be turned over. But even, the prosecution does not have to go into Odyssey and look at the statement.
Question?
Yes.
Do they?
I don't think so. Because once they do, they have to turn it over. If they are in possession of the statement, right, and in my view, even looking at the statement and becoming aware of it, I think that they would have to turn it over. And there's two reasons for that. One is both the statutory discovery obligations of the prosecution, and that's Penal Code Section 1054.1, which is pretty expansive. But then also even broader are the constitutional discovery obligations under the Brady case, Brady discovery. And Brady is super broad. Brady is basically anything that could help the defense in any way, even if it's just impeaching a witness. Anything. It can be exculpatory, but it's not limited to that. It's anything that might be favorable to the defense, or that might lead to favorable evidence for the defense. It's very, very broad. And that Brady duty, the prosecution is self-executing. So court doesn't have to order it, court shouldn't have to order it, the prosecution has to do it immediately. Unlike the statutory obligation, where both sides are required, there's certain things that are required to turn over at least 30 days before the trial. But on the Brady, you don't get to wait to 30 days before the trial to turn over this great exculpatory arson report that's been sitting in your file for 2 years. So, all right. So one reason why a prosecutor might not want to look at the family law file is because then they're going to have to turn it over. But what I've always thought about is, if you're a lawyer, don't you want to know? Wouldn't you rather know in advance what the cross-examination might look like, or how strong your case is, rather than have me drop it on BJ prosecutor right before I'm asking, or right as I start to cross-examine on that issue. So, I don't know, it's just different. You know, I've never been a prosecutor, so I don't know. I can definitely understand that they wouldn't want to turn something over that they didn't have to, but I think I'd want to know. I'd want to know because I just think that's what I'd want to know. So.
And Judge, I think you're way ahead of the family court with Odyssey. I don't think that you can get pleadings online yet, not yet.
You guys can?
We can.
Family law, not till March.
Yeah.
I can.
Not every
I use something called
They have the technology.
Odyssey Judge's Edition. But that's for my case.
I'll get on that subscription.
I didn't know. So you guys can't just go online and look up.
It's there, but nothing happens when you click it.
Oh,
Yeah.
I can see it.
To the criminal defense part, you would want to go to the records department in the Spinetta courthouse for this.
You can see CHROs on Odyssey already. Those documents are available on Odyssey.
Oh, interesting.
I don't have access, I mean, it'll show me the register of actions, but I can't pull up the actual petitions file.
Not until.
Right.
Yeah, for CHROs?
Yes.
Oh,
Oh,
Yeah.
those should be there. There's a tab that says view documents. If you scroll
Yeah.
to the bottom, there is a link to each document and it pulls it up as an image file, which is very annoying, but it's an
Yeah,
image
it's
file.
hard
pulled
to
up.
print those.
Somebody show me.
I always
Yeah,
treat
'cause I
all
do
my
this all the
clients'
time.
perspective, people that come to see me, I just put them in Odyssey first.
Oh,
Let's just see what's there.
yes,
Always.
absolutely.
That's part of my consult process, my
Yeah,
screening
me
process.
too,
Yeah, through
me
Odyssey.
too.
It could be a part of a conflicts check.
Yeah.
Yeah.
Actually,
I assume that, say there's a CPO in place and then a DVRO is requested as well. Any kind of written response, say Wendy does actually file one, that's not considered any breach of the CPO, even though it's directly a communication, right? Because she has, like, the opposing party has to be served. It would seem disingenuous to prevent them from filing something, but it would need to be served, obviously, by somebody else, and not accompanied with like a big FU letter that says like that.
yes, you are allowed peaceful communication for the purposes
Of
of
serving legal paper.
serving.
Yep.
Right. And so we're just talking about the initial stages. This is like within the 25 days of when you first sought the DVRO request, very early. So the other reason why I think it's not a good idea to file a response could be that criminal counsel is not even on board yet, right? And so the judge and I both think it's very important for the family law and criminal defense counsel to be in constant communication. So you're not filing something where the criminal defense counsel says, you said what? Right? So that is another reason why it may be a disadvantage. But to your point, we are going to talk about at a later date, right? At a later date when we are going to move forward with the DVRO hearing.
And I think, I can't remember if you fleshed this little piece of it out, that because the response on DV 120 is only due to be filed and served 2 days prior to the initial hearing, did we talk about how?
Oh, I wasn't going to say it, but
Okay,
feel
well,
free to say it.
So these are like the dirty little secrets, right? Like, because you know how busy the family law judges are, and you filed it 2 days before.
It's not even-
Maybe if you're lucky, the judge is going to become aware of it 1 day before the hearing, or like the morning of the hearing. And so the question is the judge going to be able to fully digest, especially if you filed like a 50-page DD 120 response? Is it really going to be helpful at the hearing? I'm not saying that's a reason not to file it, but I'm just saying practically, will the judge have had time to fully digest it if it's only 2 days before?
Judge, to me, when I file something, the judge, of course, reads everything and digests everything and has thoughtfully considered it before calling my case on the bench.
Yes.
Yes. Yes, of course.
So that's why I wasn't gonna say it.
No, I was just saying with a practical perspective, I'm not saying the judge won't have read it, but will she have had a chance to fully digest it?
Oftentimes, the response is accompanied by about 100 pages of text messages or
Right.
email messages. So,
Unauthenticated.
yeah, I haven't even had a
And the
chance to read
police
through
report.
that.
And what?
And the police report, which is.
Yeah.
Okay, so now, should Wendy seek to trail the criminal matter? Should she seek to age the criminal matter while the family law case moves forward? And there are advantages and disadvantages. So, if at trial, Wendy is found not guilty, or the charges are somehow negotiated or pled down, then it's possible that Wendy could use that as negotiating leverage, maybe even in a family law case.
I'm sorry, it's me, I gotta pick up my daughter. But I don't have to pick up my daughter. That's my alarm, sorry.
We won't tell the family law. Tell me I need to get picked up more. Okay, all right, sorry. So, there are other things, like it does happen, and it's actually very common in domestic violence cases that the alleged victim becomes not interested in prosecution. And so that can sometimes happen as the case gets older and people calm down and they have different feelings about it. Then another thing to think about is maybe Wendy can build up some good pattern of visitation in the family law case while the criminal case is, growing barnacles. And Wendy will have an opportunity to conduct discovery in the family law case. Now, it's possible this could cut the other way. If the criminal case is still ongoing, if nothing's happening in the criminal case, let's say there was a supervised visitation order, maybe the family law judge is going to think, well, I don't know what's going on with this criminal case. I'm really reluctant to grant unsupervised visitation, so that could be a disadvantage. And another possible disadvantage is, and this would be, I guess, trailing the DVRO and not adjudicating the DVRO. As long as the TRO stays in place, perhaps Dorothy is an additional protected party as well. So it just could, yes?
This is an interesting point that I'm curious about, because you show up at the hearing on a temporary, you haven't filed a declaration on behalf of your client, but she wants to see her daughter, who until this incident she had equal custody of, and it's a teenage daughter. So you as the judge, how do you evaluate where you go with, in this fact pattern, where you go with the initial visitation?
I don't know if they're doing this still, but would they refer that family to custody counseling and then come back? Even if the DVRO isn't adjudicated, it stays as a temporary?
Well, yeah, it's separate, but it's non-recommending.
Right.
So assuming let's just say, so they go, they don't reach an agreement, they come back to you, then what are you looking at?
I don't know. Are the judges open to hearing a request for interim visitation?
Some are, in experience. It depends on, how busy they are that day.
Depends on.
How busy they are that day.
Well, if you filed your 50-page DV 120, sorry, a lot busier. Let's see. And then from this is sort of on the other side. If the criminal case is resolved,
Yeah, should Perry seek to trail the criminal matter?
Right. So if the criminal case is resolved and it's final on appeal, then Wendy arguably no longer has a Fifth Amendment privilege, right? The criminal case is over, she was convicted, it's final on appeal. As long as we're talking about the same conduct, she doesn't have a Fifth Amendment privilege. She might not be allowed to invoke in the family law case.
Question on that?
Sorry?
Don't interrupt your flow, I hold my questions, but, what if the criminal matter is trailing for forever, and you may get to this already, but, and then the DV alleged perp wants to then postpone the DVPA proceedings, the family law proceedings, potentially indefinitely, because we know the wheels of justice turn slowly in criminal proceedings. And so, when do I know, when can I know for sure that it's not going to be charged? Because frequently the outcome is it will never be charged.
Well,
That's like, what, a decade?
Sometimes the DA will tell defense counsel, you know, we've made a filing decision, we're not going to file. The thing is, you know, if something happens after that, the DA isn't precluded, as long as it's within the statute of limitations, the DA isn't precluded. Let's say there's another incident that occurs 6 months later. The DA could then file both that incident and the prior incident on one charging document.
Yeah.
So
essentially it's, if they can slow play, the alleged perp can postpone for a very long time the DVPA proceedings by saying, Your Honor, I'd love to go forward today, but there's this thing hanging over my head and I'm invoking my Fifth Amendment, so you just got to reissue the temporary restraining order in the DVPA case, and I'll see you next year.
And does that happen in practice?
It has, yes.
Yeah. Well, we have a slide here, and I haven't seen it.
Go ahead.
Oh, I say I've had a situation though where a person has asked to plead the Fifth and to trail, and the judicial officer said, no, you're going today, you can plead the Fifth, or you can take a restraining order against you, but this is happening today, not trailing.
That's the kind of.
We've got
have a slide on.
We've got a slide on.
Oh, I'm sorry.
Several.
It's coming up, it's coming up. What did he say here? Get a vote, this is the Scott situation, the TRO gets continued for a longer duration. It could be more difficult for Wendy to present a defense in the DVRO proceeding. And then, of course, any declarations or testimony that Wendy gives in that proceeding could be used against her in the criminal case.
Am I correct in the assumption that Wendy should preclude Harry from seeking the trail, right? She has the right to have her as the protected party. If she objects to
Don't forget, Wendy's the perp.
the DV matter, if the TRO is continued, because he's asking, maybe I'm reading this wrong, he's asking to trail the criminal matter with the restraining order proceeding, right? The DVRO proceeding?
So Wendy is the defendant, the criminal defendant. Remember, she was the one.
One, no, I'm talking about, sorry, the civil proceeding. And maybe I was misunderstanding the direction you're trying. I was reading this as if the civil case was getting kicked out further.
Right, the
So
civil
Wendy
case
can
is
stop the civil case from getting kicked out further because she is the restrained party and she has a right to have it heard. Correct?
Yes, that's true. That's true. Sure, if I assume if she said, hey, I want my DVRO heard today, I need these orders finalized, I want to see Dorothy, then yeah, at some point they're going to have a hearing. I mean, yeah, you're right. Okay.
Okay, so I'm going to go through this quickly. We only have 25 more minutes. So if the DVRO does trail the criminal case, what about visitation? Does that mean that Wendy never gets to see Dorothy again since it was a no visitation order? And so Wendy could, at any of those DVRO hearings, ask for a change in visitation. Definitely recommend at the initial hearing, Wendy asked that the no visitation order be changed to, at minimum, a professionally supervised visitation. And you can see right there, I have a list of types of visitations going from the most restrictive to the least. And so there are limitations to all of these. If you go to a professionally supervised visit, you are limited often by cost and sometimes availability of your professional supervisor. If you go with a non-professional supervisor, like somebody's grandma, somebody's uncle, then you are limited by the relatives' availability because nobody wants to spend Monday, Wednesday, Friday for 3 hours and then Saturday for 6 hours supervising you and your kid, right? You can also have exchanges that are supervised. So it's just the someone making sure that the interaction to exchange the child from one parent to the other is kosher. And then obviously down at the bottom, you've got unsupervised visits, which is the least restrictive. And so the downgrading of the restrictive to less restrictive visits can happen even after you've had your DVRO hearing, and a restraining order after hearing is granted. So anytime after that, the restrained party can still keep asking upon a change of circumstance for less restrictive visits. Okay, so can Wendy depose Harry in a DVRO matter? I'm going to call on the criminal defense attorneys. Ashley, what do you think?
If he's invoked his Marcy's Law rights, then no.
Oh my goodness,
God,
you are awesome.
Gold
Okay,
star.
very nice. Okay, Marcy's Law, what is that? That is the Victim's Bill of Rights. And one of those rights is that victims have the right to refuse an interview, deposition, or discovery request. However, Marcy's Law does not apply to civil cases, and a DVRO hearing is a civil case. So, what are we to do? Does that mean that Wendy can get around a prohibition and depose Harry? Well, luckily, we do have CCP 2025.420, which allows a court to grant a protective order to protect any party, deponent, or natural person from unwarranted annoyance, embarrassment, or oppression, or undue burden and expense. And so the statute also gives some examples of what type of protective orders you can ask for. They can range from no deposition be taken at all to deposition being taken only under specific terms and conditions, to a deposition being taken via written form rather than oral examination. And so oftentimes what I have seen is the parties will stipulate to something like, okay, well, Wendy is allowed to take the deposition of Harry, but Wendy can't be in the same room just to comply with the restraining order, and Wendy can listen in on the deposition and communicate with her deposing attorney, via phone. And I've also seen that Wendy's, the computer where Wendy is watching, essentially when you do a video conference for the deposition, the screen can't show Wendy's face because, Wendy the big bad wolf could be mean mugging poor little Harry the deponent and intimidating him.
BJ, I'm sorry to have your questions, but if there's both a criminal case pending and a civil DVPA case, why can't the protected party just invoke Marcy's Law and say, yeah, I know you served me with a deposition notice under the Civil Discovery Act, but I'm just invoking Marcy's Law and sorry, I don't even need to get a protected order.
Because it doesn't apply in a civil case, right? And so if you don't have that right in a civil case to invoke,
My concern is it's the same or similar, it would be the same conduct theoretically here.
And I think that you could make that argument and, under CCP 2025.420, ask that no deposition be taken at all and use Marcy's Law as your explanation as to why this is wrong. This is just a runaround of Marcy's Law so that you can still depose the alleged victim in this case. But I don't think that you can just go in and say to the judge, well, pursuant to Marcy's Law, we can't have a deposition or any form of discovery, but you can come in under the CCP 2025.
And could you argue in opposition to 2025 to say, put a protective order on it so it can't be used in a criminal case, but only in the family law case? Is that... Or does it then still be able to come in as like a prior inconsistent statement if there's a protective order?
That's a very interesting question.
It's very broad. It says that the court for good cause shown may make any order that justice requires to protect any party, blah, 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 from all these things. So I suppose.
I mean, I think the judge could,
Yeah.
if there was a protective order on it, it couldn't be used in any way in the criminal case?
Right. I don't know though. I mean, could you really, thing is, could the judge make that order and bind the prosecution who's not a party to the family law matter?
I think all evidentiary motions maybe have to be heard by the trial judge, right?
Yeah.
Anything limiting evidence has to go to the trial court.
Okay, so now we have a poll. Now, assume for right now that Wendy is representing herself in the family law proceedings. Can Wendy hire a private investigator to investigate and follow Harry in order to obtain information to help in the DVRO case?
You're gonna allege that it's third-party harassment.
Well, or even her, yeah, because under Penal Code Section 136.2, sub A, sub 1, sub D, the court can issue an order that the restrained party have no communication. Oh, I'm sorry. No, sorry. In the no contact order, she's not supposed to contact him directly or indirectly by any means, and you're not supposed to harass, attack, strike, threaten, assault, hit, follow, stalk, molest, keep under surveillance.
Yeah.
Keep under surveillance.
Keep under
You're
surveillance.
not supposed to keep them under surveillance. Okay? So, question 2. Wendy is represented by Scott Landry. Can Scott Landry hire a PI to follow Harry around?
I'm not a, restrained person in the order, right?
You're
You're an
not.
agent of the
You're
restraining
representing
order.
You're not. So it's interesting because in 136.2, it talks about no contact, no communication, except through an attorney. That's the no contact, no communication. But that doesn't apply to the section that talks about not keeping under surveillance. So it's interesting. It was an interesting question.
Yeah, I think I can't because I'm my client's agent, right? It's just it's too close for my company.
Maybe you wouldn't want to, yeah.
Yeah, and so if you represent the protected party in the DVRO, remember that broad catch-all category of other orders to protect and keep the protected party safe, you could specifically ask for that. And I imagine you could do that in the CPO too. There's also the other orders
That's true.
section.
At the very bottom of 136, sorry, at the CR120, what slide is that, do you remember? At the very bottom, there's like other orders. Sorry.
Oh, this is gonna
Other orders, including stay-away orders from specific locations. It's box 18. Now, you don't have, the judge doesn't have very much room to write it in there, but you could write down no hire PI to follow around.
So the answer is yes. The attorney can hire the PI to follow them around unless there's a specific order. I mean, that's like pretty intense to like just follow them around, but like investigate and such.
Right, in my research, in our research, we didn't see anything specifically prohibiting the attorney, and I tried to look for, like, does it say that the attorney is the agent of, and therefore you can't? There isn't, but I would not, I wouldn't do it, just like stop.
Okay, oh, go ahead.
But if you don't care about your license, go ahead. Sorry.
I was gonna say, we've got some really good stuff and 13 minutes, so.
Oh, okay.
Is it okay? We're gonna like, try to power ahead.
It's 1 minute of announcement.
Okay,
Oh
all
my,
right.
okay.
So we've reached the point where Scott Landry's vision of no more continuances. The judge is over it in family law. This has been on my calendar 8 times. I've reserved 3 hours for this DVRO evidentiary hearing this afternoon. No more continuances. We're going forward. Okay. So, should Wendy testify? The criminal matter is not resolved. Well, so here are some things to consider. Have you talked to the criminal defense attorney? How likely is it that the criminal case is going to go to trial? If it's not probably going to go to trial, then does she really care about her Fifth Amendment privilege, right? If that case is headed towards some type of negotiated disposition and that's really clear, then who cares? I mean, that's one way of looking at it. Now, what if you don't know? Ashley says, I don't know, they're being unreasonable, they're asking for a year county jail, no electronic monitoring, I just don't know, we may have to try this one. So we're going forward on the DVRO. What if Wendy invokes? She doesn't testify. Is there some way to get in her self-defense defense in the DVRO proceeding? Well, what about her statement to the neighbor? Oh my God, I didn't know what was happening. I was scared. He was coming toward me. He was spitting. I didn't know what he was going to do. I raised the hammer. Okay, remember who else was there who saw everything?
Dorothy.
I'll get you, Dorothy. So, should Dorothy testify? Is that an option? So let's talk about the statement to the neighbor. You might argue, Scott, wait, were you representing Harry or Dorothy? I don't remember. You can't represent
Whoever
both.
pays me.
Yeah, but you can't represent both.
He's a defender of wealth.
Okay, all right. Dave Erb is representing, Dorothy's daughter, Wendy. Dave Erb is representing Wendy. And he argues to the judge that Wendy's statement to the neighbor, that pretty good, exculpatory statement that more or less provides a self-defense, that should come in as a spontaneous statement under Evidence Code Section 1240. And that might actually fly. I think it could.
Admit it.
Yeah, Judge Bowen is leaning towards admitting the statement as a spontaneous statement because there's been something happening that's really enough to excite her. There really hasn't been any time for reflection or to contrive something. She went right over to the neighbors and just like, what? So, and it does relate to the circumstances that caused the excitement. So. And of course, she observed it personally. And we have some cases there, and I just feel like we need to credit Justice Simons because we stole these cases from his book. So if you're not familiar with his book on evidence, you should get familiar with it because it's every trial lawyer's and every trial judge's can be handy. So, okay.
So what about having Dorothy testify? So it's rough on a kid to have to testify, right, in any circumstances. It's even rougher on a kid to have to testify potentially against one parent. And so Harry might want to prevent the testimony. So what can Harry do? So we've got Evidence Code 700 that says that essentially, irrespective of age, you can testify. And there are some circumstances under Evidence Code 701 when a witness is disqualified, such as when they're incapable of expressing themselves to be understood or incapable of understanding the duty to tell the truth. So a very young child might not be able to testify. There's also Evidence Code 765 that talks about having safeguards for witnesses who are under the age of 14. And you can read right there what those safeguards are, but it doesn't stop someone from calling a 13-year-old child such as Dorothy as a witness. Now, some of the family law practitioners here might say, wait, so she's not 14, right? She's only 13, so what about she's not of sufficient age and capacity to testify? That's Family Code 3042, right? But alas, Family Code 3042 only applies to custody hearings for a child talking about who they'd rather go and live with. And in this case, we're talking about recipient witness to a domestic violence. So unfortunately, it does not come into play. So if you must call a child to testify in your DVRO case, California Rules Report 5.250, which was meant to implement the custody testimony of Family Code 3042. I think it provides a good guide as to what a judge, what you can ask for protection in having a child testify. And then if you are a really skillful negotiator, you may just be able to stipulate with the opposing counsel on what Dorothy's statement would be and submit it in written form.
Especially if her statement, I'm sorry, talking
No,
about
no,
over
no,
here.
I was just gonna say something.
I mean, I was so proud when we came up with this idea. We were really excited. We thought, that's a really good idea. And then we thought, who would ever do that? But it is a really good idea, so people should think about it.
In theory.
And what if Dorothy's statement was really straightforward, and it was the statement she made to the police, and she's told other people, and her story's been consistent, then do you really want to drag Dorothy in and have her testify if everyone can agree that this is what she said at the time, and we'll stipulate, and the judge can consider that. We thought it was great.
Yeah.
Okay, so now, this is a situation where Wendy does not testify, she's not filed a response, and Harry introduces her out-of-court statements. This ends tonight. And he gets that in under Evidence Code Section 1220, essentially statement of a party opponent. But then you might want to provide some context to that statement if you could. What about Wendy's statements to the police? What have I done? I raised the hammer, but I don't know if he meant to hurt me. Is that admissible? And we talked about her statement to the neighbor potentially being admissible as a spontaneous statement. So now, here we are. David Erb has prevailed, and he's successfully introduced Wendy's statement to the neighbor as a spontaneous statement. What can Harry do? He's about to lose his DVRO. Scott Lantry is quaking in his boots. Well, remember, Wendy is a thief. She embezzled from her employer. She's got a misdemeanor conviction for embezzlement. So Wendy hasn't taken the stand. Her statements come in, and certainly has come in against Harry. So Scott Lantry reaches into his bag of tricks and pulls out Evidence Code Section 1202, which says, I'm going to tell you what it really says. That's what the legislature says it says. But 1202 says, when a statement comes in from a hearsay declarant that's coming in for its truth, you can impeach that statement just as if the person was on the stand and testified. Came in, you got it in as a spontaneous statement. Now, Scott Lantry's stuck with it. He sees his case crumbling before him. And then he says, Judge, I want to introduce evidence, a certified copy of the record of conviction from just a few years ago that Wendy's a thief, she's an embezzler. And that comes in as impeachment. And David Erb says, what are you talking about? That's not admissible. She didn't testify. You can't impeach her. And Scott Lantry says, yes, I can. 1202, I can impeach her just as if she testified on the stand. And that is right. So there you go.
Question.
Yes, ma'am.
What if her statement is not offered for the truth of the matter asserted?
So it does have to be evidence of a statement by a declarant. Well, okay. Any other evidence offered to attack or support the credibility of a declarant. So it has to be a declarant.
So if I'm impeaching the officer for saying something wrong with her statement and not offering it for the truth of the matter, but rather for shoddy police work.
But wait a minute. Are you impeaching the officer with an inconsistent statement that
Say he said there was absolutely no indication that she was afraid for her life at all. And I was like, well, isn't it true that she stated to you that, that she was, that she didn't know if he was coming at her. And it's like,
and you wrote that in your police report.
And you were, yeah.
But I think that is coming in for the truth. Because it's a prior statement of this witness, right, that can be considered for the truth. I think that should come in for the truth. Certainly if you represent Wendy, you want that in for the truth.
Yeah. But if it
Anyway,
somehow didn't come in for the truth, what is...
Yeah, I mean, I think 1202 is really for the situation where you're trying, something's come in for its truth. It's a declarant, hearsay declarant. And you want to cast doubt on that, and you want to impeach them just as you could if she had testified on the stand. 1202 is wonderful, incredibly underutilized, very exciting.
Okay, Wendy is going to testify. Now, we are 1.5 years after the incident. We've appeared before Judge Bowen 8 times. He says no more continuances. So now, does she file that written response before the hearing? You've had more time to develop the case, to interview witnesses. But the statement may still be used against Wendy in both the DVRO and the criminal case. However, it does give the judge a good preview and summary of what her testimony is going to be. And by now, judge will also have more time before a long cause hearing to consider the response and digest it. And also, if you were to stipulate with opposing counsel that for the DVRO trial, we're just going to submit on the declarations and we're going to cross-live. Yes, you can do that in family court. It will shorten the DVRO trial. I think that a written testimony is much more controlled than putting your client on the stand and asking him or her questions. However, you do have to see that a judge who will be judging the credibility of your client may be more inclined to find your client credible during your direct testimony where you're showcasing how awesome your client is, as opposed to just allowing the judge to see what your client looks like when she is being crossed, because that could look very ugly. Regardless, whether you choose to file the response now or not, please consult with your criminal defense attorney.
All right, we are running short on time, but we have some quick questions. How can a criminal conviction affect the family law case? Of course, the big one for parties with children is the mandatory 3044 presumption. And just for the criminal practitioners, if there's a finding, the family court makes a finding of domestic violence, and that could be a criminal conviction, then there's a mandatory presumption that it's not in the child's best interest to have that parent have legal or physical custody. It's a rebuttable presumption, but it's mandatory. It has to be applied. I don't know if it's still happening, but the entire time I was in family law, the appellate courts just kept coming out with these decisions, reminding the trial judges again and again, yeah, no, this is mandatory. You do have to do this. This is mandatory. Okay, so there was another.
Okay. And not to put any pressure on your criminal defense attorneys, but a misdemeanor conviction is pretty bad for the parent. So some of the rebuttable presumption, if you're convicted of a misdemeanor conviction DV, is that there's a rebuttable presumption against the injured spouse paying the convicted spouse spousal support. Injured spouse is rebuttable presumption that injured spouse is not going to contribute towards the attorney's fees of the convicted spouse. And also, the injured spouse can ask for a date of separation as of the date of the incident or even earlier if the facts so allow. And finally, this is a big one. The injured spouse may, under circumstances, be allowed to take 100% of the community pension or retirement. So if you have someone with a long-term marriage and they have a very nice Contra Costa County pension, that is a lot to be taken away from the convicted spouse. So no pressure. Judge, what happens?
That's just misdemeanor conviction for DV, right? Not like
Correct. Correct. Misdemeanor conviction for DV.
Right, I think it was conviction where there's a term of probation that has 097 terms, Penal Code 1203 097 terms, and it has to be within 5 years before the filing of the petition, the dissolution petition.
And to rebut the presumption, the burden of proof is just preponderance of evidence. You can also, if the convicted spouse has a history as a victim of domestic violence, you can present documented evidence. And what constitutes documented evidence? There's that case. Go take a look at it.
Yeah, it's like brand new. It's like since I was in family law, so I was excited to read it. Okay, so, and it gets even worse. If it is a domestic violence felony or a violent sexual felony, under Family Code Section 324.5, it's not a rebuttable presumption, it's a mandatory prohibition on spousal support. So the injured spouse should not have to pay the abuser spousal support. No attorney's fees paid by the injured spouse. The date of separation shall be the date of incident or earlier if requested. And the same, too bad, so sad, community property interest in pension. And, and I was just going to say, so felony domestic violence, that's pretty clear. Violent sexual felony, And then they're going to make family law practitioners dig way into the penal code. And that a violent sexual felony means any offense that's described in certain sections of Penal Code Section 667.5 sub C, and criminal law practitioners know that that is a list of really bad crimes. Those crimes are referred to as violent felonies, so they are all strikes under the strike law. That's not the only place you find strikes, but that is one of two places where those are defined. And violent felonies also require, if it's a prison commitment, that the person must serve essentially 85% of the sentence. So there's no half time, there's no 2/3 time. You're limited to 15% conduct credits. And I don't think that that has been affected by any of the sentencing reforms that's happened. So what are these sexually violent felonies? Well, you might guess, but it's rape, sodomy, oral copulation, sexual penetration, essentially with a foreign object, and rape or sexual penetration in concert. Those are the ones. Now, what did I say? 4324.5, it's really, draconian. But there is always a safety valve, right? Because if the convicted person can present documented evidence that they are the victim of a violent sexual offense or domestic violence perpetrated by the other spouse, then the court may determine, based on the facts of the particular case, that one or more of these really bad draconian things in 4324.5 doesn't apply. So it's not really a rebuttable presumption, but it's kind of, a safety valve. We don't want something, terribly unjust to happen.
So the final takeaway is, Judge, shall we say it together?
Yes.
Frequent and continuing contact with the family law or defense counsel.
That's right.
Thank you both.